Welcome to Company Law Revision. We're going to revise Company Law April 2022. And question 1 says, that's question 1A, highlight 6 ways in which a person might become a member of a company. 6 ways in which a person can become a member of a company. And one of the ways is by allotment of shares. When a person is allotted shares by the company, then it means the name of that person will be put in the register. So the person becomes a member of the company. Then also by subscription to the constitutive documents. We mean the articles of association and also the memorandum of association. If you are a subscriber, then it means your name is supposed to be included in the register, so you become a member. Another one is by transfer. This transfer can happen, for example, when a person buys shares. When you buy a share or buy shares, the name will be included in the register, so you become a member of the company. Then another one is by transmission. So transmission is usually involuntary. This is a case whereby somebody dies or somebody becomes insane or bankrupt. So those shares will be transmitted to another person. So that other person's name will be included in the register, so it becomes a member of the company. Then another one is by estoppel. So estoppel is a case whereby you have been improperly registered as a member, then you end up enjoying the rights of membership. For example, attending general meetings, getting dividend, and so on. So in that case, you have become a member by estoppel. Then you can also become a member by agreement. So in agreement, this is whereby a person's name is included among the members of that company after the other members have reached an agreement, so the person becomes the member of the company. Then question number 1B says, identify 4 types of particulars to be registered with respect to a company's beneficial owner. So these particulars include, we have the name of the shareholder. So the name must be included. Then we also have the postal address of the shareholder. Then we also have the number of shares that the person is holding. Then we also have the value of those particular shares. Then also the class or the type of shares that that particular shareholder is holding. Then question number 1C, a person dealing with a company is entitled to assume in the presence of facts putting him in doubt that there has been due compliance with all matters of internal management and procedure required by articles of association. With reference to the rule in Royal British Bank versus Taquand, summarize 5 exceptions to the above statement. So before you look at those exceptions, we can have a brief look at the case. That's the case of Royal British Bank versus Taquand. In the instant case, the directors of Royal British Bank Limited issued a bond to Taquand and borrowed money from him. The articles of association authorized the directors to issue such a bonds with the approval of a proper resolution. The directors were empowered by the articles to borrow on bonds only such a sums of money as the company in a general meeting resolved to borrow from time to time through the passing of necessary resolution. However, no such a resolution was passed for authorizing the issue of bonds, and the directors issued a bond to Taquand without the authority of a necessary resolution. Later, the repayment of the loan defaulted and the company was questioned to be liable. The claim was refused by shareholders in the presence of the resolution. The issues raised in the given case, the question arose as to whether the company was liable for repayment of the bond. The rule laid down in Royal British Bank was a stark one. The case is popularly known for laying down the doctrine of in-house management. According to this principle, if an act is authorized by articles or memorandum of a company, an outsider is entitled to believe that all the specified formalities for carrying out that act have been followed by the company. In other words, persons dealing with a company who have satisfied themselves that the intended transaction is not inherently inconsistent with the memorandum and articles are not required to inquire about the validity of internal proceedings of the company. That's to say that when they contract with a company, considering that intended transaction falls within the purview of its memorandum and articles, they are entitled to presume that the provisions of the memorandum / articles have been observed by the officers of the company. It's not the duty of outsiders to ensure that the company fulfills its internal regulations. It's sufficient that they ensure that the proposed transaction is permitted by the charter documents of the company. They by no means can know what or does not take place inside the company. So the judgment of this case, regardless of the fact that the bonds were issued without being authorized under the resolution, it was determined that Takwand could sue on the bonds since he was entitled to presume that the resolution had been legally passed. Now, according to this question, we look at those particular exceptions. So the first one is that knowledge of the irregularity. If you are an outsider, then you are aware that there is some irregularities on matters of management. Then it means this rule does not apply to you because you are aware of such irregularity. Then another thing is that in case of illegality, this doctrine only applies to legal transaction. So whenever there is an illegal transaction involved, then this doctrine also does not apply. And another exception is that when you are a member, it means you are an insider. You are supposed to know what is going on within the company. So for an insider or a member, again, this doctrine does not apply to him. Then, in case of lack of knowledge of the powers of the company, so we have some documents which are in public domain. For example, the articles of association of the company, memorandum of association of the company, which a person can be able to access. So if you have capacity to access and you don't do that, then again it means that this particular doctrine will not apply to you. Then also it does not apply in case of negligence. So in this case, if the outsider will know the non-compliance or irregularity, but by making a reasonable inquiry or fails to make reasonable inquiry for something you can easily know, you can easily get, then it means you are negligent. So in the case of negligence, again, this doctrine will not apply. Then if the officers acted beyond their capacity or beyond their authority, that means that also this doctrine is not going to apply because those people acted beyond their powers.